Welcome to Lawyer Up with HMC, where we unravel the complexities of legal battles, share insights into high-stakes litigation, and provide strategies for navigating the legal landscape. Join us as we delve into and discuss common legal issues and interview industry professionals and experts in the field. Whether you're a legal professional, a business owner, or simply curious about the world of litigation, our podcast offers valuable knowledge and practical advice to empower you in your legal journey. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, hmclawyers.com. Now here's the host of the Lawyer Up with HMC podcast, Kristen Hagg.
Hey, welcome back for another episode of Lawyer Up with HMC. I'm your host, Kristen Hagg, and in today's episode, we're going to be discussing evidentiary issues and other challenges associated with advancing civil sexual assault cases. And our guest for today is Erin Brassard. She's the founder of STAND. It's an organization for survivors of sexual assault, run by survivors of sexual assault. Their mission is to provide support to and promote healing for survivors of sexual violence. Welcome to the show, Erin.
Thank you so much for having me.
And our HMC lawyer guest for today is David Corrigan, or as we call him, Dave. Dave is a partner at HMC. He has over 30 years of litigation experience. His practice has historically focused on commercial insurance and commercial litigation. However, over the past couple of years, he has spent a significant amount of his time advancing a claim on behalf of a group of brave survivors who suffered sexual abuse between 1988 and 2004 while attending at a junior high school here in Calgary. Welcome, Dave.
Thanks, Kristen. Good to see you again.
I know, it's been a while since earlier this morning. So, yeah.
Yep.
No, it's always nice to have a good group of people here. And I do want to, for anybody that is watching online, this episode is being recorded over Christmas. So that explains the antlers with lights all over them that are protruding from my sweater here. So hopefully everyone's okay with that. So, albeit from differing perspectives, both of our guests today have knowledge and expertise with respect to stigmas around sexual assault and firsthand experience with how myths and stereotypes are used to suppress claims, discourage victims from starting or continuing their claims. So today we want to discuss some of those myths and stereotypes and how they impact and present challenges for civil sexual assault claims, and how maybe victims and their lawyers can deal with or get past some of those issues. But before we get into that, it would be great to hear from each of you about your background as it relates to the topic. Erin, why don't we start with you? Could you maybe tell us a bit about yourself, your organization, and how your involvement with STAND has led you to being sort of exposed to the court system on sexual assault cases?
Yes, for sure. So I started STAND as a survivor myself. I first experienced sexual assault when I was 17 years old. I didn't tell anybody what happened to me. So at first, I actually didn't even realize that what happened to me was sexual assault because I had always been taught it would be someone, holding me down, someone I didn't know. So when it was someone that I knew that I had continued to say no to and finally stopped saying no, I didn't actually realize that what he did was rape. And it took me years until I actually saw that person again and how it made me feel to really understand that what he did was so wrong. After that experience, I ended up experiencing sexual violence numerous times in my late teens and early 20s. And it wasn't until someone that I love with my whole heart confided in me what had happened to them in high school that I decided that I couldn't stay silent anymore. Something had to be done so other people didn't suffer in silence, as so many do. And that's how STAND was really created. So I created STAND so that no other survivor felt alone. Once I started opening up about my experiences, I realized that there is so much, it's a safe place once you know someone else has been through it. And when I shared, numerous women would come and confide in me and men about what had happened to them. And usually it was for the very first time. So STAND was created, and what it does is it offers peer support first and foremost. So you're able to connect with someone who has been through something similar, and they're able to listen and kind of walk that journey with you and help you navigate all the different systems out there, including court proceedings and things like that. Another big thing that STAND does is we believe that every survivor is an expert in their own healing, and that everybody heals differently. So we offer numerous different holistic healing workshops, including art therapy and equine therapy, as well as subconscious imprint technique healing. So every single survivor has multiple modalities and ways to heal that offer them lifelong. So it's not a one and done for us. So yeah, that's a little bit about me and what STAND is about.
Yeah, thanks for sharing. And we know here at HMC, having been involved with your organization over the last several years, that you're obviously doing incredible work. So thank you for everything that you're doing on that front. And now, Dave, maybe you can tell us a bit about how you got involved in litigating civil sexual assault claims and what it is that makes you want to take on these difficult cases.
Well, I think, to be honest, it was a former colleague, Jessica Kozak, decided that this is an area that she really wanted to branch out into. And so we looked into how we could become educated enough to feel like we could competently handle the cases. And we did some workshops and some reading and so forth to try to disabuse ourselves of some of the unproductive notions that people have about sexual assault and frankly surrounding the rape myth paradigms. And so we did some work and began to take on some cases, and we were involved in a number of different cases together. And Jessica's now moved on to work for the courts, but we've kept practicing in this area for the last, I don't know, 4 or 5 years. And at my age and stage, you get to thinking that wouldn't it be nice to do shit that matters to people as opposed to just fighting over money? And I've had lots of big money cases between oil companies and insurance companies and things like that. And none of that provides the same level of emotional involvement as these types of cases. So through to retirement, I intend to do some work in this area. So it's that.
All right. Well, thank you, Dave. And yeah, I know firsthand, particularly being your next door office neighbor, yeah, you've definitely poured your heart and soul into this and become very educated in the area. And we look forward to learning more from you today. And you mentioned the rape myths, which we're going to get into here. Erin, could you maybe explain to us what a rape myth is and what some of the common rape myths are?
Yes, for sure. There is honestly so many rape myths. It's actually crazy to think about, but some that are really important that I like to highlight and focus on are, one, being sexual assault is rare. So a lot of people think that not very many people get raped or experience sexual violence, when in fact 2 in 3 women in Alberta experience sexual or have experienced sexual violence, and 1 in 2 girls before the age of 16. So the numbers are, it's way too common. And a lot of, when I say that, people still never think it's going to happen to them or their daughter or their son. And the fact is it happens to anybody. It doesn't matter your race, your gender, your income. It can happen to absolutely anyone. So that's a big rape myth that's out there. Another one that I kind of mentioned before is that the assailant is going to be someone you don't know, when in fact, most of the time it is going to be someone that you know. And I believe it's in the 80s for sure. I don't know the exact percentage, but over 80% of sexual assault victims know the perpetrator. So that's another rape myth that isn't talked about a lot. And that's another reason that it creates so much silence around. When it's someone that you know that has done this to you, it's a lot harder to talk about it. It's a lot harder to press charges against that person for known reasons, because you don't want to do that to someone you know. And there's a lot of people that you are in your group of friends or things like that that make it a lot harder. Maybe a third one that I'll touch on would be that it involves physical violence. And when in fact, most of the time, sexual assault is not a physical act. So you're not being held down, you're not being beat. And the reason for that is because most of the time when a sexual violence occurs, the victim is going to freeze. And that is not something that we decide to do. It's something that your brain forces you to do in order to survive that experience. And that was something that was really hard for me to learn, because I have experienced sexual violence numerous times and I never fought back. I always froze. And I blamed myself for that. I thought, okay, maybe if I fought back, it wouldn't have happened to me, or maybe it wasn't that bad because I didn't fight back. Maybe they didn't know. When in fact, when someone chooses to commit this crime, they know what they're doing. It doesn't matter if you fight back or not. They know that you don't want this to be done to you. And it doesn't matter if you fight back or not. So those are three that maybe I'll touch on. And if you want more, I can add more later on.
Well, maybe I'll flip things over to Dave, because he'll have, in handling these types of cases, well, number one, he's gone through some workshops and things and been educated on some of this stuff and learned more about it, but also having handled the cases has probably encountered them in practice. So maybe Dave, if you want to comment further on the rape myths or some of the common ones you've seen.
Sure. Well, I guess the not fighting back one is perhaps the most pervasive and dangerous one. And Erin's exactly right. People freeze. This is part of our lizard brain as a survival mechanism. And it's just one of these things that people who haven't been through it don't necessarily understand. And clearly not everyone's the same, but in many cases, that's what happens. And people don't understand that. And so, a recent example was there was a Queen's Bench judge, I don't know, 5, 7, 8 years ago, who was removed from the bench for asking a woman why she was sitting on a sink in a washroom when someone was sexually assaulting her. He says, well, why didn't you just drop your bottom into the bottom of the sink so they couldn't get at you? And that judge, of course, was removed after going through a long process. That's the mindset. If you didn't fight back, there's no evidence that this was an assault. And the pervasiveness of this is it sort of deals at every aspect of the justice system. You've got people who victims who don't fight back know that they'll be judged for not fighting back, so they don't complain. And then if they run into cops or prosecutors or whatever that perhaps don't understand this, and certainly the big city police departments now have properly trained people. But if it happened in a different context, then that rape myth would probably hinder the ability to charge. And then if you have a jury trial and people don't understand this, and you just need 1 out of 12 who's ignorant to get a mistrial, then again, it makes it really difficult to get a conviction. And so all of these things sort of play into it, and it's a problem throughout the whole system, and these things sort of reinforce each other in a way. People feel so bad, so it makes them vulnerable to cross-examination on these points because they're embarrassed, and there might be friends or family members that are asking them this. They think they're being supportive, but they're trying to understand, and it just feeds on itself, and it makes it really, really difficult for people. I look at a couple other things as sort of rape myths as well that sort of are pervasive in our society. How someone is dressed is an example. If someone were spending the whole, if someone is dressed in a provocative fashion, then that person was looking to attract sexual attention, and ergo that's a signal that they're interested. So that not so much in the legal system anymore, but certainly in society at large, those kinds of thoughts exist. And then you've got the idea that if you didn't report right away, well, if it actually happened, you would have reported right away. You would have gone to the hospital. You would have done this. You would have done that. And again, people who think that, they're using their quote common sense, but really they're using uninformed social norms to dictate how someone should respond to these things. And the fact is that the embarrassment of it all is such that people don't want to report, especially if it's someone they know. There's just so much that goes into that, and it takes people time to come around to the idea that they need to report. So if someone doesn't immediately go report, doesn't immediately phone the police or whatever, there are those people that would look at that and say, well, that's a strike against the alleged complainant or the alleged victim, because they aren't doing the things they should have done in order to deal with this. On the clothing thing, another example of how we've got these deep-seated prejudices. There was a case, kind of a famous case in Alberta, and I don't remember the name of the case, but the basic facts were is a young girl, I think she was 17, went to, I think it was a trailer park, and met some guy, and was sexually assaulted by this guy. And the Court of Appeal, there was an opinion from a judge on the Court of Appeal that it basically said it must be understood that she did not go to this meeting in a bonnet and crinolines, meaning if people who don't want to be sexually assaulted are going to be dressed in a demure fashion, and she wasn't. And so he was using essentially this long-standing rape myth to justify his credulity about the story. And that's the kind of thing that happens. Now, that particular judge got eviscerated by a different judge at the Supreme Court of Canada sometime around the late 90s, I think it was. And that was, part of the changing understanding about these things, and, generally moving forward in a more positive direction in terms of education and trying to treat people in a more informed fashion.
And I just want to.
Oh, sorry.
Oh, well, I was just going to put a pin in the thing about the justice system, and certainly a few just about sort of how we've seen these biases play out. And maybe getting into more discussion about how things are changing and things like that. But certainly if you had more comments on that, we can come back to them. I was just going to, there's a couple things that came up in what you said that I wanted to ask Erin about, and maybe she could provide a little more insight on the delayed reporting thing and some of the, more explanation behind, the victim and survivor's perspective on that, and why it's important that we understand that it takes people time to process these things and come forward.
Yeah, for sure. Thank you for asking. I wanted to talk a little bit about that. It's making the decision to report is something so personal, and I have so much respect for anyone who has found the courage and the strength to report a crime like this, because like David said in a lot of his examples, you're putting yourself out there to be re-victimized for a really long time to try to get justice. So it's something I never reported anything that ever happened to me. And it's something I still kind of go back and forth on a lot within myself. And it has been well over a decade of things that have happened to me. And I still haven't found the courage or haven't made the decision whether it's something that I'm going to decide to do or not. And what I tell all survivors when they're making this decision is they have to do what's best for themselves. I make sure they know what they're up against, because it's not an easy process to go through as a victim. So it's a hard decision to make, and I can't imagine making that decision so early on in your healing when you're going through something so traumatic. It would be a really, really hard thing to do. So I hope that kind of answers your question a little bit. And I think another big reason is another rape myth that comes to mind and why it's so hard to report is that so many people think that this is something that people lie about, and that the false accusations are really high when it comes to sexual assault. And the matter of the fact is it's not actually at all falsely. People don't falsely accuse others any more than any other crime. The numbers show that it is 5 or 6% of false accusations. And I know, being a survivor, someone that's going to go to the amount of pain it's going to cause them to report something like this, they wouldn't do that unless it actually happened. And most survivors that I've ever worked with that have gone through the court process and press charges, they're doing it. Their ultimate motivation for every survivor that I've worked with is to make sure that it doesn't happen to someone else. They're usually doing it to protect others in the future, because we know that people that commit this crime commit it over and over and over again. And by the age of 21, someone on average has committed this time 6 times. So
yeah, no, that's very helpful. And I was going to say that, I mean, one indication of how the system, or the courts at least, or legislators are changing perspectives on this is, across Canada, legislators have, there's no longer a 2-year limitation. Survivors are able to bring forward these types of claim whenever. And that just at least reflects an understanding of how these things work. There's actually, I was going to say, there's the Supreme Court has, in this is a criminal case, but they rejected the notion that complainants in sexual assault cases have a higher tendency than other complainants to fabricate stories based on ulterior motives, and therefore are less worthy of belief. So this is something that is starting to get integrated into the courts. But you also touched on something else there about the system sort of being set up to favor the abusers. And I think Dave probably has some further insight on this.
For many, many years, that those kinds of safeguards have been utilized by accused in criminal law too. Just the very idea in criminal law that you have to prove something beyond a reasonable doubt. Well, what is that from a percentage basis? Is it 95%? Certainly, I think most people would say it's more than 80%. What's more likely? It'd have to be 80, 90, 95%, 99% in some people's minds, beyond a reasonable doubt. So right there, there's this, if it's close, if you want to believe one person or both people or whatever, the system is designed in such a way, and that's not just in relation to sexual assault, but when you stack on all of the rape myths and sort of the warped human psychology, it just makes that burden to get a conviction that much harder. And for years, what happened is if a lawyer knew his client couldn't be put on the stand because they were a shitty, lying piece of crap, and they knew that the complainant was a person who would come across well to a judge or jury, their only gamut was to try to discourage the victim so much that they would give up before they got to trial. And this led to a pattern of behavior amongst criminal defense lawyers that was referred to as whacking the victim. And so what they would do is they would intentionally be vicious at the preliminary inquiry. So in a criminal matter, if you elect a trial by judge or jury in the Court of King's Bench, you are entitled to a preliminary inquiry, which is where they have to present enough evidence to show that the case should go forward. It's a low bar, certainly not the same as a conviction. And you would think, as a criminal defense lawyer, that if you had good stuff that you were going to use to try to discredit the victim, you'd do it at the trial in front of the judge and jury. You wouldn't give a dry run for the complainant to see what all your tricks might be. But there was sort of an institutional understanding amongst the defense bar that what your best bet is just to beat the shit out of the victim, so they don't want to go ahead. And this was kind of exposed in someone recorded I think it was a CBA presentation, and I think it was in Ottawa in the late 80s, where they were discussing this, big name lawyers discussing this strategy, and called it whack the victim. Just make them feel like shit, make them understand that this is going to be awful, use every rape myth available, grind the crap out of them so they don't want to go ahead. Because if they still take it and they go ahead, you're going to get a conviction. Because they can't treat the victim that way at trial because they look like assholes. So this was their one shot to just be vicious, and that became a pattern. And so when we talk about how the system is so hard on victims, that's a perfect example of how these safeguards, which are designed for a good purpose, could be used for a bad purpose in the context of this kind of a crime.
Yeah, I'm curious. I mean, I do want to kind of get more into, because we've been talking a lot about just claims in general. Obviously, there's kind of some overlap when we're talking about criminal and civil cases. But before getting to that, I did want to see if, Erin, if you had any further comment on what Dave had to say there, or whether any of the people that have come through your organization, if you've seen any of this, firsthand, or seen people go through this, and how difficult it can be for them.
Yeah, so I actually, I hadn't heard of it until our meeting to discuss this podcast, actually. And as soon as Dave started talking about that in the preliminary, I instantly thought about a young woman that I worked with for 3 years because the court case takes so long. And I remember her calling me after her preliminary, and she could not believe what she went through during that. The defense lawyer went at her for so many things, including previous mental health that she had been diagnosed with, how much she weighed compared to the perpetrator. I couldn't believe what she had been asked when she was on the stand, and she was hysterical. And she said to me, "I don't know if I can do this." And I had no idea until I talked to Dave that this was a tactic that lawyers use. And it's so nice to know that now, because now I'm able to tell survivors, at preliminary, prepare them for that if they're going through a preliminary, and then let them know, when you go to court, it might be as bad, but it might not be. Let them know that this is a tactic that lawyers use so they can be prepared for that. Because after that, she waited June, that her preliminary was in June, and her trial was not till the following January. So a year and a half, 18 months that she was waiting, and so scared to go through that court process again for that entire 18 months. She was petrified that she was going to have to go through that again. So I think it's important that people know this. And I didn't even know that, for someone who has taken a lot of education and things like that. That's not something that's taught. So I think it's really important that survivors know that, to be prepared for it, and to understand why it's done. And it shouldn't be allowed, obviously. I think it's absolutely ridiculous. Like I said, I couldn't believe the things that she was being interrogated on. And she said they were just coming at her hard. So it was hard to support her through that. And it was nice, after I talked to Dave, the first person I called after our meeting was Caitlin, to let her know what I had learned, and I wish I knew during the time she was going through it. So.
Okay. Yeah.
So on that point, Kristen, I should indicate that the current rape shield laws and the laws that have developed in the last, let's say, 25 years through either legislation or some of the case law developments, the areas of inquiry are not necessarily, well, they're not the same as they used to be. And so even in the preliminary context, some stuff that used to be asked can no longer be asked because of the rape shield laws and some of these protections. That doesn't change the fact that that it's still the place that's likely going to be the worst for someone going through this, because the lawyer doesn't have to, the defense lawyer doesn't have to worry about pissing the judge off or being an asshole, and that reflecting bad on their client, because a different judge or a different jury or a jury will be making the decision sometime down the road. So it's the constraints of being perceived poorly by the judge don't apply. Doesn't matter. So the behavior will be worse than it would be otherwise. So.
Okay. Yeah. And I guess that sort of leads into one of the other things. I mean, actually getting into the process then, because so all this like preliminary inquiry stuff that we're talking about, that is in the criminal context. But we've been dealing with here more at HMC, obviously, is the civil side of things. So Dave, maybe you can comment on just some of the differences in the civil
Sure.
system, and what it is that you do when a new client comes to you to try and advise them and prepare them for what they might be getting into.
So there are a number of differences between the criminal system and the civil system. For the person going through it, I would say the primary differences are that the burden of proof is different. So in a civil lawsuit, the burden of proof is more likely than not, meaning 51%. In a criminal case, it's beyond a reasonable doubt. So there's a huge chasm between those two burdens of proof, meaning it is much easier to prove something in the civil context than the criminal context. That doesn't mean it's a fun process, unfortunately, but it does mean that the likelihood of success is much higher than it is in a criminal court system. The other thing to keep in mind is in the civil context, the client is largely in control as to how they want to move forward and if they want to give it up at some point, if they're tired of it, they can't take it anymore, whatever, that will be their decision. Now, I should say there can, in theory, be cost consequences to that. But once something is turned over to a prosecutor, in theory, it's up to the prosecutor on behalf of the people to go ahead if they think it's in the best interests of society. Now, they generally don't like to push cases if the victims no longer wish to push them, but there might be circumstances where that happens. So that's different. In a civil law context, what generally happens is you meet the person, you take down the information, you order records, medical records, and other records to make sure you understand the person as best as possible, and you prepare a statement of claim, which is the constituting document for the lawsuit. That statement of claim is then served, and it's served on the perpetrator, and in some circumstances, it's also served on the perpetrator's employer, if someone else bears some measure of legal responsibility for the actions of that person. So after that, the first big step is deciding which records need to be produced. It's called an affidavit of records. A lot of victims are very concerned about their private thoughts being shared with the other side, be it counseling records or whatever. Generally speaking, there are protections against having to produce many of those kinds of things, where the health of the victim might be compromised by production. So there are times that you can protect those records and provide at least some comfort to the person that their whole life's not going to be laid bare in the context of this lawsuit. After that, you go through what's called a questioning, where you get to ask questions of the defendants, and the defendant's lawyer gets to ask questions of the victim. Now, courts are quite aware of the fact that the perpetrator should not be in the same room as the victim. So these kinds of questionings can occur in such a fashion that you don't ever have to see that person again during the course of the lawsuit. So that in a way is good, and it's one thing that people certainly ask us about for sure. So after questioning, the next step is to get expert reports if required and set the case for trial. The vast majority of cases settle. And so people who are going into civil litigation need to understand that the only remedy you can expect is money. And you can only expect that remedy if the person has money. So if you've been assaulted by someone without financial resources, the idea of a civil lawsuit is probably not a great one, unfortunately, because there's no way to collect. But leaving that aside, the system can be good for some people in terms of trying to come out the other side of this experience and feel like you've been heard and you can move forward.
I was going to ask, when it comes to, right, because there's a couple of things when it comes to the civil side where we've got questioning. There's not a preliminary inquiry, but in a way, you're being put through a similar type process. Do you notice, is there attempts to use these tactics of discouraging people from going forward in the questioning context? And then also there's the flip side benefit to that is that the accused can't avoid being put through that. I mean, can you comment further on the difference there?
Yeah, so I think your lawyer is able to object to inappropriate questions. They may not choose to in certain circumstances, but there's a measure of protection there. And the vast majority of people are now at least somewhat informed about this and have some understanding as to the psychic price that's paid by people who've gone through this. And so most people are not looking to make this worse, because if they are, most lawyers, I should say, if that's their tactic, they have to understand that at some point they're going to have to face a judge and deal with that, and that's a consequence. There can be enhanced costs and any number of different remedies when people are behaving in an unethical and unduly a cantankerous fashion with a victim.
And one of the other things that came up in what you were saying was about the financial wherewithal of the defendant and whether or not it's worthy of pursuing them. But I guess as compared to, in the criminal case, the only person that's going to stand trial is the accused. But if they did do this in the context of employment, or some other type of vicarious liability situation, then there's the possibility of including them as a defendant in the lawsuit, and then there actually may be a pocket or a remedy that's available, right?
That's right. And these things are quite fact specific in terms of there's two types of liability that can be triggered in an employment context for an intentional tort, like a sex assault. And the two types are what we call direct liability, meaning the company that hired this person didn't do what they were supposed to do, whether it's in terms of supervision or proper screening when they hired them or something. There was a case recently in the States where some big hotel company got just whacked for tens of millions of dollars for hiring a dirtbag who ended up sexually assaulting one of their guests. And they didn't do the proper screening. He had a criminal record for this kind of thing, and they paid us a steep price for that. So that would be what we call direct liability. The vicarious liability piece is, this gets quite technical, but there are times when the assault occurs during the course and scope of employment, even though it's an intentional act, that it might be such that the employer is vicariously liable, which is essentially liability that's not founded on fault. It means they're liable just because of the relationship. So we absolutely explore those types of things in every situation to hopefully find a way to you know, to find a pocket, because absent a pocket, there's the process is less than successful. So,
And I mean, we are getting a little short on time here, and I do want to turn things back over to Erin to kind of have the last word on things. And I guess in particular, I'm wondering if you yourself have any advice for survivors that are thinking about or in the course of, you know, the legal process, and going that route. And then on top of that, if there's, you know, things specifically that your organization can do to support people that are involved in the process.
Yeah, for sure. I wanted to touch quickly on the civil side of things, that I feel like, because when it comes to civil and the only thing you can get is money, it creates the problem of, again, another stereotype that the victim just wants money, right?
Mhm.
That's a big one, especially when it comes to professional athletes or anyone that's in the media. It's, oh, this person is just looking for a paycheck, right? And again, I just want to make it clear that no one would put themselves through that for a paycheck. And also, most of the victims, they're not looking for that money. We've actually had victims donate their settlements to STAND, to help more survivors. So I think it makes sense that that's obviously what a civil court case is about. But again, it kind of adds to that stereotype of not believing victims that our culture has. So I guess what I would like to finish on, anyone that's kind of thinking about or toying with the idea of pressing charges, or not knowing if they have a case, or should I go civilly, or do I have a criminal case? Who do I talk to? Who do I call? I would suggest, number one, contacting a sexual assault center, contacting STAND, so we can explain to you who the best place to go to, that there are police officers, like David said, nowadays, who are specifically trained in this. And you won't be as re-victimized as maybe you would have been years ago by people that have not had the education of how to respond to people who've experienced this. So there's support out there. There's answers for you. There's more information. Get educated about how you can report, what your options are, and just know that you will be supported by the people that you talk to if you reach out to the right people. One thing that I love about HMC, and I always send anybody that comes to STAND to HMC, that I think that you guys do, that I don't know if most places do, but you go and get the education. It's not like you just learn online. You go and take a 2-day course, like David has gone and taken a 2-day course on how to respond to disclosures of sexual assault and abuse. And that is huge, to know how to support someone, because you can say the wrong thing very easily that can re-traumatize victims and recreate those feelings of shame and guilt that all survivors have. And I think the biggest thing in healing for survivors is shedding those feelings of guilt and shame that shouldn't be yours in the first place. I sometimes do have those thoughts that come back to me, and of, I should have done this, or I shouldn't have done that. And I have to like snap myself out of it. And the easiest way for me that I would like to share to any survivors that watch this is, I always stop and I think, if what happened to me had happened to someone I love, would I ever blame them in any way? And the answer is always like a strong no. Like a strong no when it's someone you love. So whenever you start to have feelings of that, or start feeling bad about yourself for things that were done to you, just stop and think, if this had been just done to someone else, how would I feel? And that's always a way that gives myself more self-love when I'm trying to continue to heal from the things that have been done to me. And then just to finish off, I would just always say, one thing that I like to end with is, what I wish someone had told me would have been, what happened to you was not okay. You know, so many people near the end, when I started talking about it, would be like, oh, just stuff like that happens. Like, you just have to get over it, you know? And no, it's not true. Stuff like this shouldn't happen. And what happened to you isn't okay. And there's people out there that can support you, and it's okay to be hurt by this. And there is healing to be done. And you aren't what happened to you. So.
Thank you. And I guess, Dave, any closing thoughts from you? And also, I think it would be helpful if you had some words of advice, not for survivors, but for lawyers that are considering getting themselves involved in this type of litigation, because it isn't for shrinking violets or for the faint of heart, I would say.
Yes, it's emotionally draining work in many ways. And I don't know that most people understand how sort of the psychic price that needs to be paid to see through cases that are dealing with a lot of bad shit. And, you know, when Erin was talking about her own story, she essentially described being re-victimized time and again. And that is something that happens to survivors, especially childhood abuse survivors. And why? Well, there's people who go through something like this. Often they struggle with self-esteem. They often get involved in drugs or alcohol to try to cope with the shame, the embarrassment, the pain. And that combination leads to people often being in the wrong place while impaired, and bad people will take advantage of that. And so there's this cycle that happens, and it all comes back to sort of the the idea of embarrassment, shame, and people will feel like they're damaged goods. And so, what I would say to people who've gone through something, they need to understand that it's not that they're not worthy. Someone did something bad, and it's not their fault, just like Erin said. And a person in that circumstance needs to find a way to regain agency so they are able to function in a way that allows them to move forward productively. And that regaining agency, it might be in-depth counseling. It might be all sorts of things. It might be criminal charges. It might be a lawsuit. But everybody needs to do their best to find a way to regain that agency so that they're able to move forward and not punish themselves for the rest of their life, essentially.
Well, I really actually hate to end the conversation. This has really been a great episode, very interesting. And thank you so much to both of you for coming on to the podcast. And also thank you so much for what each of you do in this area. It's a difficult area to work in. Just thank you to you guys. And yeah, I've got to wrap things up for now. And so thank you for listening, and we'll catch you on the next episode.
Thanks,
Thank
Kristen.
you so much.
You've been tuning into the Lawyer Up with HMC podcast with your host, Kristen Hagg. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, hmclawyers.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.